Congressman Marcoleta. Binigyan din ng additional time ni Congressman Epcas, Datol, De Jesus at Guya. Congressman Marcoleta, you're recognized.
Maraming salamat po, Mr. Chair. Ang pinag-uusapan po natin ngayon ay itong provision sa ating saligang batas, Article 12, Section 11, na kung saan ay sinasabi nga po yung phrase na or for a longer period than 50 years. Dito po kasi, talagang sinasabi niya explicitly, no longer period than 50 years. Ngayon po, ang sinasabi natin, katulad po nung ako'y unang tumindig dito, ang sabi ko, kung ang ABS-CBN ay mag-aspire pa ng panibagong prangkisa, baka babangga na sa provision na ito. Bakit ko po sinabi yon? Sapagkat sa totoo lamang po, dalawa po ang magiging interpretasyon dito eh. Alin man dito is within the complete prerogative of Congress. Yung pong restrictive or strict interpretation o kaya yung liberal interpretation. Totoo po na in the final analysis, it will be Congress who will use its discretion kung palalawigin yung maximum na 50 years. At sa maraming pagkakataon, totoo rin po na lumampas ang maraming mga kumpanya sa limit na yon. Bakit ko po sinabi, in particular, ang ABS-CBN sa aking palagay ay hindi na kailangang lumampas pa doon sa limit na yon. Mr. Chair, in my own analysis, I am applying the restrictive and strict application or interpretation of this provision of the Constitution. Unang-una po, isa-isa po nating ipinakikita yung nakikita nating napakaraming paglabag sa ating mga batas, lalong-lalo na po sa ating saligang batas. Kung discretion po ng Congress ang mag-extend, discretion din po ng Congress na tingnan niya na maaaring hindi na po niya extend. Bibigyan ko po kayo ng halimbawa. Ito pong sulat ng ABS-CBN sa ating chairman, Honorable Franz Alvarez, na may petsang May 28, 2020. On the issue of does the ABS-CBN application violate the Constitution requiring that franchise should only be for 50 years, considering that the company has allegedly been using a legislative franchise for more than 63 years, we submit here a list of companies granted legislative franchises. Ginawa po nila itong Annex G. At dito nga po sa Annex G, binanggit kanina ni Congressman Fortun, nauna po rito yung Manila Broadcasting Company at yung 12 po na nasa baba. Pwede ko po bang itanong sa ABS-CBN, ito po bang 13 mga kumpanya na kinalap ninyo na di umano'y lumagpas pa sa 50 years? Ninilabag po bang batas ito sa record ng Kongreso? Nung po bang ito ay pinagdidebatihan, and when all these companies in their applications for franchise within so many periods, lumitaw po ba yung maraming paglabag? Halimbawa po, Manila Broadcasting Corporation. Hindi ba dapat kayo pong magpatunay na meron silang paglabag? Hindi po kami ang gagawa nun. Kayo po dapat ang nagbigay sa amin ng katibayan na lahat ng 13 ito ay lumabag din sa napakaraming mga batas. O pwede nyo ngayong questionin ng legislature. E ang dami rin palang nilabag nitong mga ito. Bakit kami? Ayaw nyo kaming pagbigyan. Meron po bang isa man dito sa 13 kumpanya na nilista nyo rito naipapakita nyo sila, lumabag po sila at sa kabila ng mga paglabag binigyan sila ng prangkisa sa maraming pagkakataon. Mr. ABS-CBN.
Mr. Chair, hindi ko po masasagot yan dahil wala naman ako sa proceedings ng franchise application po nila.
Yun nga po. Yun nga po Kaya po binigyan ng higit sa 50 years. Wala pong paglabag. Ito lamang po yung most laudable conclusion dito kaya po, ang sinasabi ko nung ako'y unang tumindig, mukha pong ang Congress ngayon, baka bigyan po ng mas istriktong pananaw yung 50 years na yon. Ang katotohanan po nito, wala naman po kasing, maski po tingnan po ninyo yung record ng Constitutional Commission of 1986. Wala pong binanggit na dahilan kung bakit napaka-strict niya na 50 years. Wala pong sinabing renewable of another period Basahin po ninyo yung Constitutional Commission records. Hindi po nakalagay. Pwede po bang matanong si Attorney Bautista kung meron po siyang nakitang discussion on the intent of the framers of the 1987 Constitution, kung bakit po sinabi ng Constitution na for a period or for a longer period than 50 years. Meron po bang explanation doon ang framers ng Constitution, Attorney Bautista?
Good afternoon po, Congressman Marcoleta. Salamat po sa tanong niyo.
Meron po record o wala po?
Ano po yun?
Doon po dun sa phrase na or for a longer period than 50 years. Ito po kasi yung limit. Meron po bang discussion o meron po bang paliwanag kung bakit sinabi ng mga framers ng Constitution na hanggang 50 years lang?
Wala po sinabi.
Wala.
Gaya po nung in-explain ko earlier, yan pong 1987 framers of the Constitution.
Ito, yung tanong lang ko.
To know that under the 1935 and 1973 Constitutions, which have exactly the same wording as the 1987 Constitution,
Attorney, ang sagot niyo po, wala po, di ba?
as to how the Congress, the Senate, and the President have interpreted and implemented that provision. Hindi naman po nila pinalitan. Kaya ang amin pong intindi is they are accepting the way Congress, the Senate, and the President, through those many decades, have interpreted and implemented the 50-year provision, which is to limit it to the franchise or certificate only and not to the operation of the public utility. At isang Congressman Marcoleta.
Sorry po, Attorney. Para hindi po tayo magtagal, kung ano po yung tinanong lamang, ang tanong ko lamang po sa inyo, meron po bang further discussion? Ang sabi po natin, wala. Yun lamang po.
Wala po. Pero kailangan po bigyan niyo kami ng pagkakataon na magsalita rin po.
Ito nga po, may susunod pa po akong tanong
Okay po, sige po.
Okay. Wala rin po siguro nakalagay sa discussion ng mga intensyon ng ating framers ng 1987 Constitution tungkol sa pagpapalawig. Ang totoo nito, wala pong sinabi ron kung palalawigin pa ng the same year. Hindi po ba totoo na wala ring record tungkol doon, Attorney?
Wala rin po. Sa totoo
Salamat po.
pati sa Supreme Court, wala kami nakita.
O yun nga po, susunod ko pang tanong sana, meron na po bang desisyon na nanggaling sa Korte Suprema na kung saan napagtalunan doon at in the final analysis, the Supreme Court made a decision explaining that the 50-year franchise limit is renewable. Wala pa pong kaso ngayon
Wala po.
Salamat po. Bakit ko po sinabi na kung ako pong tatanungin ninyo, ay ililimit ko na lamang sa 50 years. At hindi ko na po papalawigin. Sorry po. Kabisado po ba ninyo, Atty. Bautista, yung Republic Act 5730?
Ano po ang title niya? Hindi yata.
An act amending the title and certain sections of RA 511 entitled An Act Granting Bolinao Electronics Corporation, etc., etc.
Hindi po ako familiar dyan.
Okay po, para po malaman po ninyo ang ibig ko sabihin, nakalagay po kasi sa section 1 noon, subject to the provisions of the Constitution, the ABS-CBN Broadcasting Corporation is hereby granted a franchise for a period of 50 years. Ulitin ko po, ABS-CBN Broadcasting Corporation is hereby granted a franchise for a period of 50 years from the approval of this amendatory act. Ang date po nito, Atty. Bautista, is June 21, 1969. Familiar po ba kayo sa Republic Act 5731, Atty. Bautista?
Hindi po.
Ito po ay batas na pinagtibay June 21, 1969 uli po. Kaparehong araw po, nung binanggit ko kanina. Ang title po, An Act Amending the Title and Certain Sections of Republic Act numbered 1343, entitled Granting the Manila Chronicle a Permit to Construct, etc., etc. Sa Section 1 po ng batas na ito, babasahin ko, subject to the provisions of the Constitution, the Chronicle Broadcasting Network is hereby granted a franchise of 50 years from the approval of the Amendatory Act. So kanina po, may 50 years, dito po another 50 years, 100 years na po yun. Atty. Bautista, kabisado po ba yung Republic Act 5733?
Hindi po.
Ito po may petsang June 21, 1969. Pare-pareho po ito, isang araw lang po. Tatlong batas ang pinagtibay. Ang title po nito, An Act Amending the Title of Certain Sections of Republic Act number 512, entitled Granting the Bolinao Electronics Corporation a temporary period, etc., etc. An Act Granting ABS-CBN Broadcast Corporation a franchise to construct blah 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 for a period of 50 years. Ito pong tatlong batas na ito, Atty. Bautista, para sa ABS-CBN po lahat ito. Hindi po totoo na nung kayo mag-merge ng Alto Broadcasting Corporation at saka yung CBN, isang prangkisa lang po yun. Kapag sinuma ko po ito, 50 plus 50 plus 50, ito po yung 150 years. Kanina po sabi ni Congressman Fortun, wala pa naman daw naging batas na kagad binigyan ng 50 years. Ito po tatlong batas na ang recipient po is ABS-CBN Corporation and Chronicle Broadcasting Network. 150 years po ang suma ko. Ngayon kung bibigyan pa po kayo ng another 50 years, 200 years na po yun, Atty. Bautista. Napanik po po itong tatlong batas nito.
Congressman Marcoleta? Maaari po ba ako magsalita?
Sige po.
Salamat po. Yung pong binabanggit ninyo ay mga batas na pinas po ng Kongreso at inaprubahan ng Presidente ng Pilipinas. At yung sinasabi ninyo, pagpalagay na natin kung totoo, kasi po sinasabi ko, inaamin ko, hindi ko alam, I'm not familiar with the provisions of those laws which you cite. But if it is true that you're saying that ABS-CBN was given 50 years or Chronicle Broadcasting was given 50 years or whatever, that reinforces our argument that we can exist for more than 50 years. That supports our theory, our position, that we can go beyond 50 years. It does not diminish or weaken our position. On the contrary, it reaffirms our position. At yung pong sinasabi ninyo na 50 years, ang bintang po ay hindi po dahil we violated any law or the other mass media companies violated any law. Ang subject tulong natin ay Article 12, Section 11 of 1987. Constitution whether a public utility or a mass media company can operate more than 50 years. Given na po that you have the discretion to grant our franchise or not, hindi po namin kine-question yun. Ang sinasabi lang namin ay kung i-deny ninyo, hindi po dapat dahil nilabag namin ang Section 11, Article 12, 1987 Constitution. Pwede po magsabi kayo ng kung ano pa, kahit na walang dahilan. Kung gusto ninyo, i-deny ninyo yung frankisa natin. But you cannot say that we violated a constitutional provision on the basis of the 50-year limit. Yun lang po.
Mr. Chair, can I reply?
Kong Marcoleta, please proceed.
Thank you, Mr. Chair. Mr. Chair, there is no debate. I myself would concede that the 50-year limit is subject to the discretion of the state. A franchise is a special privilege. Only the state, subject to its discretion, can extend the 50-year limit. Ang pinag-uusapan po nito, kung sakasakali po ang isang applicant ay mapapatunayan na napakarami pong paglabag at questionabling hindi pagsunod sa mga kondisyones ng kanyang prangkisa, katulad ng napapatunayang isa-isa sa pagdinig na ito. Nagamit ko na pong halimbawa yung isang manliligaw, sapagkat kahit karapatan niyang manligaw, Mr. Chair, kinakailangan naman po sigurong ipakita niya na deserving siya kung sakaling sagutin man siya nung kanyang babaeng napupusuan. Ito po ay isang special privilege. Isang pribilehyo para sa isang binata na ibigin siya ng isang babaeng napupusuan niya. Kung halimbawa po kakakitaan siya ng hindi mabuting asal, palagi ko po yung babaeng nililigawan, Mr. Chair, hindi magdadalawang salita. Nabiguin niya po yun. Ito po ngayon ang punto ng pinag-uusapan. Isa-isa pong napatutunayan kasi ang dami na po ng paglabag. Nandun pa lang tayo sa citizenship, reacquisition of ownership, pagkatapos nandun tayo sa PDRs, ngayon po dito naman, sabi ko nga, this is a subject to the state's discretion. Kung ako pong tatanungin ninyo, hindi ko na po palalawigin. Saan pa po kayo makakakita ng isang kumpanya na isa-isang araw lamang, ulitin ko po yun, sa loob ng isang araw lamang, 3 batas ang pinagtibay para bigyan ng ABS-CBN at ang kanyang subsidiary ng 150 years. Isang araw lamang po yun. Saan po tayo hahanap ng isang kumpanya na nagkaroon ng ganong pribilehyo? Pagkatapos makikita po natin sa pagdinig natin ngayon, ang napakarami nga pong nakikita nating alingas-ngas doon sa pagsunod sa mga kondisyones na inilatag sa sarili nilang prangkisa. Kaya po sabi ko, kung akong tatanungin niyo, I will apply the strict and restrictive application of that discretion on the part of the state. Wala pong debate na pwedeng palawigin. Ito pong 13 na kumpanya na inyong isinumiti rito. For the record, Mr. Chair, itong 13 ito, wala pong report na kinakitaan ng paglabag. Kaya po siguro ako naniniwala, pinalawig ang kanilang prangkisa. This is not the way to prove an argument, Mr. Chair. The burden of proof is in the application. In the applicant, hindi po kami ang tatawag isa-isa rin dito. Ibig po ba ninyo sabihin, tatawagan namin ang Manila Broadcasting, Cebu Broadcasting, Philippine Broadcasting kung bakit kayo nabigyan ng prangkisa for more than 50 years? At the very least, Mr. Chair, siguro, pinuntahan nila, in-interview nila, nakita nila kung ano-ano yung mga paglabag siguro, tsaka natin siguro iisa-isahin. But this is not a comparable case, Mr. Chair. 13 in-approve ng Kongreso, maaaring sumobra sa 50 years. But there is no iota of evidence that these companies who were awarded repeated franchises ever committed any violation in the respective franchises. Unlike and in contrast to ABS-CBN, which is under the consideration of this August Hall. Salamat po, Mr. Chair.
Maaari po ba ako mag-comment, Mr. Chair?
Sige, Attorney Bautista, one last na po bago tayo lumipat sa
Opo,
next
maraming
topic.
po salamat. Thank you po, Congressman Marcoleta. Una-una po, kami po ay kumaharap sa Kongreso to. Dahil sinabihan kami, nabibigyan kami ng patas at patag na hearing. Ang purpose po nitong congressional franchise hearings ay to determine the truth. Yan po ang sinabi sa amin. Ang ibig pong sabihin nun, bibigyan po kami ng due process. And an element of due process is a fair and impartial tribunal. Yan po ang nakalagay sa batas natin, due process. Kaya hindi po dapat nagko-conclude kaagad na ang ginamit pong salita nag-aalingas-ngas at meron po kaming violations. Hindi po namin tinatanggap na meron kaming violations. Sa aming pong puso, wala po kaming violations. Yan lang po.
Maraming salamat po, Attorney Bautista.
Salamat po.
Ngayon po, susunod po si Congressman Edsel Lagman para sa kanyang manifestation. Kong Lagman.
Thank you, Mr. Chairman. This is a manifestation or a statement disputing the allegation that the more than 50-year operation of ABS-CBN Corporation disqualifies it from securing a renewal of its franchise under Section 11 of Article 12. The purported ban on the grant of legislative franchise to companies which have operated for more than 50 years is definitely another non-issue based on the following reasons. One, there is no constitutional provision or statute which prohibits the renewal or grant of a congressional franchise to corporations which have been in operation for more than half a century. The question is not whether Congress can grant a renewal or new franchise for another 50 years to the same franchisee, but the issue is whether Congress can deny a franchise because the applicant has already operated for more than 50 years without offending the due process guaranteed in our Constitution. In fact, there are innumerable corporations which have been granted legislative franchises despite their long period of operation of more than 50 years, like GMA7, Bohol Chronicle Radio Corporation, the Catholic Bishops' Conference of the Philippines, Praha Broadcasting Network, and Associated Broadcasting Company, or TV5. Among others, not to mention power or electric companies and telecommunication companies which have operated for more than 100 years. The provision in Section 11 of Article 12, which reads, and I quote, no franchise certificate or any other form of authorization for the operation of a public utility shall be granted, etc., for a longer period than 50 years, only means that there must be a cap of 50 years for each franchise that the Congress may issue at a time. The limitation of 50 years pertains to every single franchise, but not on the accumulated years of operation by a corporation as a franchisee. Section 11 of Article 12 does not prohibit the renewal or grant of a legitimate franchise to the same franchisee after the lapse of 50 years. A contrary interpretation is errant and counterproductive because it would be fraud and unconstitutional policy of disqualifying a corporation from securing a renewal or grant of a franchise because of, quote, old age, unquote. Corporations, like wine, become better due to the passage of time. Corporations which have been in operation for more than 50 years have tremendous investments, have gained invaluable experience and expertise, and have indubitable patronage. They should be allowed to continue serving the public and the nation instead of retiring them to oblivion. With respect to mass media, there is a special and more pertinent provision under Section 11.1 of Article 16, which reads, and I quote, "The operation and management of mass media shall be limited to citizens of the Philippines or to corporations, cooperatives, or associations wholly owned and managed by such citizens," unquote. Nowhere in the provision is the effective life of a mass media enterprise pegged to a terminal of 50 years. Senior corporations must be recognized and awarded for the longevity of their public service instead of being discriminated against in the renewal or grant of legislative franchise. The Constitution did not envision or intend that the badge of uselessness must attach to corporations which have reached the golden age. Thank you, Joint Chairman.
Maraming salamat po, Congressman Lagman. Sunod po, babalikan na po natin si Congressman Kaloy Zarate na binigyan nga ulit ng 5 minuto ni Congresswoman Arlene Brosas. Kong Kaloy, meron po kayong 10 minuto.
Salamat pa, Mr. Chair. Nailinaw na po ito ng aking mga kasamahan yung usapin ng interpretasyon doon sa limitation ng 50 years under Article 12, Section 11. At kahit na ang mga tumututol dito sa pagbibigay ng prangkisa sa ABS-CBN ay inamin na rin na hindi ito usapin. In fact, Mr. Chair, in the first place, dapat hindi nga naging issue kung constitutional issue. Kung pwede bang ang isang kumpanya, pagkatapos mabigyan ng prangkisa for 50 years, ay pwede pa ba uling bigyan ng Kongreso ng panibagong prangkisa for another 50 years? No? Dahil malinaw doon sa ating saligang batas na yung limitasyon na 50 years na yon ay for a particular franchise. No? Sa isang franchise na ibinigay ng Kongreso. Ibig sabihin, kung natapos na ang prangkisang yon at mag-a-apply uli ang kumpanyang yan, ay nasa karapatan o prerogative ng Kongreso na pwede siyang bigyan muli ng another 50 years or mababa sa 50 years. At yan po ang malinaw lang na limitasyon ng Kongreso. So hindi mo usapin dito, gusto lang mo nating linawin na Mr. Chair, no, na wala pang, kaya nga nagkakaroon pa tayo ng mga pagdinig ngayon, gusto nating malaman ang lahat bahagi ng mga issues na ito at sa aking pagkapalagay ay hindi pa tayo nagkakaroon ng desisyon. No? Ang committee ito na may nilabag ang ABS-CBN sa kanilang prangkisa at dapat hindi na siya bigyan ng panibagong prangkisa. No? Dahil ang pinag-uusapan natin ngayong sa isyong ito, ang isang kumpanya ba katulad ng ABS-CBN, pagkatapos ng kanyang current franchise ay mag-lapse, pwede pa ba ang bigyan ng panibagong prangkisa? At malinaw po, I think, as admitted, no, even by those who oppose the grant of a new franchise to ABS-CBN, na pwede pa naman. No? Ang sabi lang doon ay pag walang nilabag na sa prerogative ng Kongreso yan. No? So, hindi ko na po papalawigin na napakalinaw ng provision na yan ng ating saligang batas. May gusto na lang akong itanong sa ABS-CBN, Mr. Chair. No? Kanina nabanggit na ang prangkisa ng ABS-CBN ay naigawad noong June 21, 1969 for a period of 50 years. No? So kung susumahin natin yon, ng 50 years na yan, ay dapat yung prangkisa na yan ay nag-lapse na noong 2019. Siguro ang katanungan ko po, Mr. Chair, ay ganito. Bakit ang prangkisa ng ABS-CBN ay umabot pa ng May 4 of 2020 kung ang prangkisa nito ay nag-lapse, yung 50-year franchise na ay ibinigay pala ng Kongreso sa pamamagitan ng isang batas noong June 21, 1969, Mr. Chair.
Mr. Chair, may I be allowed to answer the question?
Please proceed po.
Yes, thank you, Mr. Chair. The franchise that was mentioned, the franchises that were mentioned were issued in 1970. Then martial law was declared, and in 1974, President Marcos issued his Presidential Decree 576-E, which terminated all congressional franchise by 1981. So that was the reason why there was a need for another congressional franchise in 1994, which ABS was able to secure in 1995.
Thank you for that answer, Attorney Poblado. So, nung magdeklara ng batas militar, tinake over ang lahat ng mga broadcast facilities ng ABS-CBN, and then nabanggit ninyo, in 1981, naglabas ng isang kautusan si Marcos na ang lahat ng prangkisa ay wala ng silbi. No? So ang tanong ko po, in 1986 when ABS-CBN went back on air, no? April or September of 86, ano po ang naging basihan? Until 1994, ano po ang naging basihan ng inyong operation? Attorney Poblador, Mr. Chair.
Thank you for the question. We should go back to Act 3876 of 1931. That Act of 3846 is the first law which required congressional franchise for TV broadcast. However, with this PD 576-A, the congressional franchise under that act were all terminated effective 1981. After the termination of the congressional franchise, the permission was all granted by a regulatory agency, which was later on transferred to the NTC. Because of the cancellation of all franchises by PD 576-A, there was a confusion. Kailangan ba talaga ng congressional franchise o si NTC pwede na mag-issue ng permits? Nagkaroon ng understanding ang KBP, ang NTC, at saka ang Committee on Legislative Franchise that while this confusion still exists, the understanding is that the NTC will issue permits, but those who will be receiving those permits will have 2 years to apply for congressional franchise. And this understanding was confirmed by the Supreme Court in the case of Associated in 2003, which precisely identified this confusion.
Okay. Salamat, Attorney Poblador. Nabanggit ninyo kanina na in 1994, ABS-CBN did apply for a franchise which was granted by Congress. Is that correct?
Yes, Your Honor.
Ang tanong ko ngayon, yung prangkisa ba na yan, binigay noong 1995, was for a 50-year franchise or lower than 50 years?
It's for 25 years.
Okay. So it's for 25 years, beginning 1995.
Yes, Your Honor.
At ito yung franchise na hanggang May 4 of 2020.
Hanggang...
May 4,
Yes,
2020.
yes,
Okay.
that's the one.
Salamat, Attorney Poblador. So, nabanggit rin kanina, in 1969, tatlong prangkisa, ang ibinigay. One for ABS-CBN, one for Chronicle Broadcasting Network, one for another one. No? Sa inyong pagkakaalam po ba, pag ang isang kumpanya ay binigay ng 50 years, at ang isang kumpanya rin, another 50 years, and another one for 50 years. Ibig sabihin ba, ang karapatan ng mga kumpanyang ito na mag-broadcast will be for 150 years? Mag-total ng 150 years?
Mukhang hindi ho. The reason why there were 3 franchises, they refer to the one franchise referred to radio, the other referred to TV broadcast. I'm not sure about the other one, but they are all separate franchises.
Your Honor, dadagdag ko lang po na yung ikatlong prangkisa was not an ABS-CBN franchise po. No, so yung isa po was a TV franchise for ABS-CBN, yung isa po was a radio franchise for ABS-CBN, yung ikatlo po hindi po ABS-CBN yan. Salamat po.
Thank you, thank you po. So ibig sabihin, kung may prangkisang radio for 50 years at ang TV ay may franchise for 50 years, ay hindi ho pwedeng pagsamahin nito para 100 years both radio and TV can operate. Hindi po ganon.
Hindi po ganun.
Hindi po ganon. Dahil malinaw nga po sa ating saligang batas na ang isang prangkisa ay talagang 50 years lang ang bisa niya. No? At kung ibigay man ito sa isang korporasyon, hanggang 50 years lang ang prangkisang yan. At ang Kongreso ay mayroong prerogative na ang prangkisang yan ay pwedeng hindi ibigay for 50 years. No? Gaya ng nabanggit ninyo kanina, nung mag-apply kayo in 1994, your 1995 franchise, no, na binigay ng Kongreso ay 25 years lang ang binigay ng Kongreso. So, I think, Mr. Chair, no, malinaw na ito at ito ang pwedeng magiging ating batayan sa pagdinig na ito kung sakasakali, no, na mabibigyan ng prangkisa ang ABS-CBN, ay usapin ito kung ito ba ay bibigyan ng 50 years or below lower than 50 years, no, gaya ng binigay natin in 1995, no. Dahil malinaw sa ating saligang batas na walang prerogative ang Kongreso na magbigay ng prangkisa, no, sa isang pagkakataon sa pamamagitan ng isang batas nang lumampas ito ng 50 years, dahil yan lang po talaga ang nakasaad sa ating saligang batas. So, dahil sa paglilinaw na yan, again, gusto kong i-rehistro dito, Mr. Chair, no, na nandito pa tayo sa usapin ng pagdinig ng prangkisa ng ABS-CBN. At I think that the Chair will also confirm, no, na hindi pa tayo nagkaroon ng desisyon ang committee ito na meron ngang mga nilabag na ang ABS-CBN magmula doon sa unang issue na ating pinag-uusapan, no, hanggang umabot tayo dito sa usaping ito kung ang 50 years ba na yan ay lalabagin ng ABS-CBN kung bibigyan uli sila ng prangkisa. So, I hope na malinaw yan, Ginoong Chair, no? Para po pagpunta natin sa iba pang mga usapin, ay ganun din kabukas ang ating isip sa pagtingin sa mga issues na ito. Maraming salamat, Mr. Chair.
Maraming salamat, Congressman Zarate. Ngayon, bago po natin ibigay kay Congressman Rufus Rodriguez, meron lang pong maikling manifestation si Congresswoman Biolago.
Thank you, Mr. Chair. Simple manifestation lang po. Ang RA 5730 was franchise for TV station for ABS-CBN only. And RA 5733 was a radio franchise po because the TV and radio were not granted in a single franchise. And then RA 5731 was a franchise for Manila Chronicle, which is not ABS-CBN. It's a totally different company po, Mr. Speaker.
I disagree, Mr. Chairman.
Kong Remulla.
I have a copy of the law here. Section 7 of the said law on chronicle broadcasting is here, and I will read it as a point of order probably. The title of the same act is hereby amended to read as follows: an act granting ABS-CBN, the Chronicle Broadcasting Network, a franchise to construct, maintain, and operate radio broadcasting stations and stations for television in the Philippines. That is Republic Act 5731. Republic Act 5730 and 5733, just for discussion, at least to clarify this, one refers to radio of ABS-CBN and the other refers to television. So you have two franchises, one for radio, one for television, and one for Chronicle Broadcasting Network, which is still an ABS-CBN corporation. For the record, Mr. Chairman, all three franchises were passed in the same day.
Thank you, Kong Boying. Thank you, Kong Mickey. Next to interpolate, Congressman Rufus Rodriguez, na kung saan binigyan din siya ng additional time ni Deputy Speaker Arenas, Congressman Tambunting, Congressman Garbin, at Congresswoman Violago. Kong Rufus, you are recognized.
Thank you very much, Mr. Chairman, and good evening to all our colleagues and our resource persons. First, I would like to ask questions to Assistant Secretary Professor T, if he is available in Zoom.
ASEC T.
Hello, Congressman Rufus, I am here.
Good evening, Professor T. As Assistant Secretary of the Department of Justice, which renders opinion as to different legal issues. You've read Article 12, National Patrimony, and Section 11. And do you see any ambiguity or doubt as to the import of this provision that no franchise certificate, other forms of authorization for the operation of public utility shall be granted except to seats in the Philippines, etc. And then the last phrase is for a longer period than 50 years.
For us, Your Honor, there is no doubt as to what the 50-year limitation qualifies, and that the 50-year limitation qualifies the franchise itself.
Yes. And so therefore, there can be no doubt, there is no room for any interpretation, whether liberal or strict, because clearly that it just says that no franchise shall be over 50 years. And therefore, if the law is clear that every franchise, every issuance of a franchise from Congress cannot be more than 50 years, that is clear itself in the law. Is that clear? Is that clear to you, Assistant Secretary?
Yes, I would agree, Your Honor.
Thank you. And of course, in the case of the leading case of Republic Flour Mills Incorporated versus Commissioner of Customs 39 SCRA 269, it was stated there that when the law is clear, it is the duty of courts to apply the law. Is that correct?
Your Honor, I would have to refresh myself on that particular case, but on the principle that you stated, that is a correct principle, Your Honor.
When the law is clear, therefore, we apply the law. There is no need for Congress to consider whether to give a strict interpretation to this Section 11 or to apply a liberal interpretation, because the law is clear and there can be no more room for interpretation. And I would also ask you about whether when the law is clear and there is no interpretation, according to the Latin maxim, index animi, sermo est, speech is the index of intention. Speech is the index of intention, as decided in Alamo Garments versus NLRC. 268 SCRA 497, indeed, the speech that is written into this clearly states that every franchise, no franchise, can be issued but not more than 50 years. Is that again very clear in the law, ASEC T?
Your Honor, I'm not completely familiar with that particular maxim, but it appears to be just a version of what you stated earlier, that if the law is clear, we must not give further meaning to it. So I would agree, Your Honor.
Yes. So in that particular case, also, it comes to mind that there is another Latin maxim that is very clear in this particular case on the clear provisions of Section 11, Article 12. And it says, verba legis non est rescindum. From the words of the statute, there should be no departure. Would you agree with that particular saying? That when the words of the statute is clear, there can be no departure. There can be no putting of words into